Now, your lordships put that question just on rising. So let me answer, ABCD, that particular question. I'll continue with my sequence after, but lordship put that question, that had you allowed possibly the 30th vote to have worked itself out or other things, then your lordship would have had, so to say, an actual
Chetan,
test.
3 बजे
with the courtmaster. Didn't to come with the courtmaster. Now, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your lordship put in a nutshell. There are 5 very interesting answers to it. Directly to your lordship, very important query. And a related query of Justice Shah at that time. A. This act was followed on 30th by the swearing in along with BJP persons. Just note, I'll make the point in a minute. Just note, 30th June was the swearing in along with senior members of the BJP. 3rd of July, 3 days later, the direct answer to my Lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your Lordship will call it, or a vote of a virtually identical nature happened at the Speaker's election. Now, clearly, there is a whip, there is a direction. You can't vote for the Speaker. You are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required. This is a 2-1B without going into a single fact. I'll give your Lordship the judgments. Each of these acts your Lordship has already held in judgments to be a direct violation of 10th schedule without any facts required. If I vote for a Speaker and I'm under a discipline of my party, you can't vote for him. You don't require anything else. You only need to see the voting. Did I press that button or not? Nothing else is required to be seen. That is on 3rd. So what my Lords is saying, nothing could change between 30th and 3rd. 3 days, no majority would change. No numbers would change. Then the third answer is the 4th of July. Again, an identical trust vote took place for Mr. Shinde. Again, you were told not to vote. Again, you voted. Same people, same vote, same system, same everything. 4th of July, a trust vote in the affirmative for Mr. Shinde. So my Lord has ample proof. My Lord rightly said, how will we know? We'll have to go into something. This is a very, very interesting case where 2-1B requires nothing, 2-1A also requires nothing. Normally, your Lordship, 2-1B can be a per se completely, but something may be required for 2-1A. Here is a case where both 2-1A and 2-1B are per se. Very rare combination. 4th reason. So swearing in with the BJP, it's on cameras, everybody sees you. 3rd July Speaker's election, 4th July trust vote of Mr. Shinde. Now, the 4th reason. Even the acts, if your Lordship were to go back, these are enough. I'm only giving by way of addition. I don't need to go back. I am now giving your Lordship the seemingly contentious issue, which is not actually contentious. The seemingly contentious issue, which is not contentious, is that on 21 and 22nd of June, you did not attend a meeting despite a direction in writing, please attend the meeting. The direction is on record, your non-attendance is on record, admitted. My Lord will now look at it in demurrer. I'm trying to make it as simple as possible. No investigation, no inquiry, no evidence. Just look at it in demurrer. Second event is that you went with the BJP and others to meet the governor on 30th June. That's also admitted. It's on record, in the press, on photographs, on press reports. Admitted, no evidence required. as your lordship noted, this visit on 30th led to the swearing in which I have already mentioned. Now, which of these will not fall foul of 21A, forget 21B, Malus. 21B is more per se. Malus, what can be the defense? I'm asking myself hypothetically, Malus. Your lordship will also see the practical. Yes. I mean, what can be the defense? That these photographs are forged, all the media is forged. I was in Malus, Timbuktu, I never went to the governor's house. That can be a valid defense. Nobody's taken the defense, you can't. Now note two more interesting things, Malus. Rana, para 48. Lordship knows Rana very well, Malus, the Constitution bench. Specifically says that the act and conduct of going to a governor would constitute disqualification. That's Constitution bench. Citation the 2007 4 SCC 270 PDF page 834 of the first compilation.
It was read yesterday.
Read. Only Malus para 48. So
Rajendra C. Rana.
I beg one.
Rajendra C. Rana.
Correct, Rajendra C. Rana. So Malus, this is very interesting again. The fact is admitted and the law is covered. What is it that a lordship has to do by way of an exercise is my question to myself. With great respect, nothing, Malus. Fact is undeniable, admitted, and the law is covered. And covered too by a constitution bench. We are not saying, Malus, I can even, Malus, bow down with great respect in a very contentious issue. Your lordship says, why should we not send it back? There is no issue here. Now note the second judgment, Srimant Patil gives the citation. Srimant Patil is the Karnataka judgment. Para 174 and 176. Para 174 and 176. The citation is 2020, volume 2 SCC 595. Three learned judges. This
2020.
2020, 2 SCC 595. The PDF page in the first law compilation is 1249. It's starting page, I'm sorry. The relevant para is 174 and 176. At PDF page 1307 and 1308. This holds the second point. Not attending meetings is culpable. This is the inception. 21st June and 22nd June you didn't attend meetings. This judgment holds that not attending meetings is sufficient to disqualify. So, Malus, in this 5 sets of facts, facts are admitted, law is covered. Now, you can always say that we want to do this, we want to do that. But if there is a purity and a social and a political evil to be controlled by 10 children, then Malus, this requires no adjudication of any kind except, Malus, the formality of a notice and looking into it. And what is the, even till today, what can be the defense of this, Malus? I am prepared to accept a new defense today. There cannot be a defense to these things. This, Malus, is the light of, but I had finished on subject 2. Putting to you notice and risk, on your own risk and cost, telling you in advance, warning you. Now, Malus, kindly consider, why is this principle? It is, Malus, for what the phrase my Lord is used time and again, the majesty of the law. It is not an empty rhetoric. Imagine, Malus, how much strengthened the rule of law is when your lordships in a rightful case does not one but 2 or 3 things. One, Malus, your lordships accepts fallibility. There is a line of cases of actus curiae that we were wrong. Justice Bhagwati, Malus, in a case I must thank my learned friend Mr. Shibbal to point it out, said to accept fallibility is no act of heroism. So, Malus, then the consequence of accepting fallibility must follow. Otherwise, Malus, accepting of fallibility is empty. So, your lordship is now, Malus, coalescing these principles, actus curiae, ibi ius, etc. Imagine, Malaj, the strengthening of the rule of law when your lordship says demolish this building even though we believe it's going to cause a lot of misery. Whereas the last one your lordship did took almost, Malaj, 6 months under your lordship supervision because 3 dates were extended. I believe my Lord Justice, Chief Justice was on the bench, Malaj. But Malaj, it happened because your lordship had a finding, had a view of the merits. And your lordship said restitution, restoration of status quo ante is vital for the necessity for the majesty of law. Now we will just see 2 striking examples in the 10th schedule when your lordships did this. We have talked about, but we haven't shown that actual para. You tell lordships against what odds your lordship still said no, we must uphold the law. Navam Rebia first and Rajendra Singh Rana second. And this is not at all an upholding of Navam Rebia. We are challenging Navam Rebia on the sole point of disabling. The fact that I rely on Navam Rebia for this doesn't at all. I'm entitled not to be hit by a stopple on that at all. Now kindly turn to Navam Rebia. Just note the paras. 214.1, 0.3 and 0.4. This was the case, as the lordship remembers. Governor, speaker, preponing date. Your lordship knows now, we've argued for 3 days. Your lordship knows the facts. But see what the court did at the end. It could have found a number of reasons to avoid doing this or not giving the answer or postponing it. Deciding not to decide is also a form of adjudication. But when your lordship is convinced of the merits, your lordship decides to decide howsoever severe the consequences. Let's kindly see this now. 214.1 is at iPad, PDF page 1158. 1158, first volume, the compilation first volume. My lord is seen, but this part my lord is not seen. This alone vindicates the rule of law. This alone vindicates the strength of the court system, not only the apex court. And this sends a clear message that howsoever high or whatever the consequence, the consequence must flow if your lordship is convinced. Now, there could be no more scrambled egg in the context of 10th schedule than Navam Rebia. Your lordship's unscrambled it. Please see 214.1. The order of the governor of 9th of December 2015, preponing the 6th session of the Arunachal Legislative Assembly from 14th January to 16th December of previous year 2015, is violative of Article 163, read with 174, and as such is liable to be quashed. The same is accordingly hereby quashed. I'll skip the next one, come to the next after next. 214.3. Now this is even more important. Remember, time had elapsed in between. Navam Rebia was decided on, give me the date. This is important, the date is important. 13th July. 13th July 2016 is the decision. Show the first page. 13 July 2016. These events related to almost 8 months earlier. New government had come in. It was very easy to say so many things and not do this. But the court, if I may say, did the right thing in terms of consequence. All steps and decisions taken by the Arunachal Pradesh Legislative Assembly pursuant to the governor's order and message of 9/12/15 are unsustainable in view of the decisions at 214.1 and 214.2. The same are accordingly set aside. It was argued, as is argued frequently, that even if your lordship holds it illegal, the intervening decisions will not be set aside. Your lordship hears those arguments every day from this side of the bar or whatever. But this is, if I may say, it's the constitutional walking of the talk in case, once your lordship is convinced. Next, in view of the decision at paras 0.1 and 0.3 above, the status quo ante as it prevailed on 15/12/15 is ordered to be restored. That's 8 months earlier. That's why the date of 13 July versus the date of December 15, there's a hiatus of 8 months. A lot has happened in 8 months, while most of all the government is changed. Otherwise, all these principles, etc., will remain paper principles. Now, Malas, in Rajinder Singh Rana, the matter was more directly addressed as a juristic principle about you decide or send it back to the speaker. So that's my next case. Rana is Malas 2007 4 SCC 270. First bunch Malas compilation of case law, PDF page 834. And I will read Malas with your auspicious permission, paras 12, 44, 45, and 52, 53. It has nothing to do with the law. It is to do with once your lordship is convinced, what is the consequence? It's ibi jus, ibi remedium. It is actus curae. It is consequence. It is subject to. It is warning. All that is the point I'm reading on.
What page did you say was that, please?
The page starts, the judgment start, para 12 Manas, is at PDF page 849. 834, the case starts. Here the argument was made squarely that kindly decide. And the rival argument was don't decide. Let the speaker decide. The respondents, may I read Manas? The respondents in the writ petition, the MLAs constituting 37 BSP members who left the party, are the appellants in all the appeals, except the appeal arising out of the special leave petition filed by the writ petitioner Maurya. Whereas the respondents in the writ petition, challenging the decision of the majority of the bench, remitting the matter to the speaker, the writ petitioner in his appeal challenges the order of remand to the speaker. The writ petition says order of remand made by the majority on a plea that on the pleadings and the material available, the High Court ought to have straightaway allowed the petition filed by the writ petitioner for disqualification of the 13 MLAs. So squarely the issue is joined. Now come to 43. 44, I think. 44 at page 865. Normally, and if I may say so, the contentious issues in this case would be far, far more than the contentious issues in my case. Far, far more. Normally, this court might not proceed to take a decision for the first time when the authority concerned has not taken a decision in the eye of the law. And this court would normally remit the matter to the authority for taking a proper decision in accordance with law. And the decision of this court itself takes on the relevant aspects.